Hello, good evening.
Hello, ma'am. Good evening.
Hi, good evening.
Madam, I had tried doing the assignments by what last time one of the fellow mates showed. I don't
Hmm.
remember her name.
Hmm.
She had showed, but I didn't get a correct idea what she had shown last time for
Okay.
doing the assignments.
Okay. So probably what you could do is anytime during the next week, Saideep, you can connect with Dr. Anchal. You have her number, right?
Yeah, I do have.
So you can just connect with Dr. Anchal and you can ask her to just run you through that on the portal.
Yeah, yeah,
She will
exactly.
probably take a 5, 7 minute presentation for you. We
I
will
think
request her.
this for me also it is required because I also not present in the first orientation session. I was absent actually. The,
Which
fir-
one?
that I think Dr. Achal, she has given the first 1 hour orientation program how to do the courses. At that time, I think all it is mentioned. So I asked later that whether it is possible to go. I think she told that it is available into the recording.
Recording.
So
Okay.
first,
Even if it is not there, what you could do is any of you having difficulty, you could just connect with Dr. Anchal. And, or maybe, if all of you have a difficulty, just post it in the group chat. We are all on a WhatsApp group, right? So you can just
yeah.
post it on the group and request Dr. Anchal if we can have a 5, 7 minute session,
Yeah, that is
quick
enough.
session, right? That would help.
Okay, thank you. Thank you.
Yeah. In the meantime, let's just have a discussion around the previous session and what has happened over the last week. Okay, so we had some kind of an orientation regarding the session, and we understood the basics of IPR, right? So can you just recapitulate? Can we just take about 3 to 5 minutes and just try and see what we can recapitulate of the previous session? Shall we do that? So, what were your key learnings? Probably each one of you can just take one minute or 2 minutes. Just what is top on your mind of what you learned in the last class, or probably if you just went back to the reading material or read an article about what we discussed in the last class. If you spend some time, regarding the discussions that we had in the last class. Okay, okay. So maybe Saidip, you can just come on audio and you can just share with us what were your key learnings, one, two, or three key learnings of the last class, and is there any reading that you did over the last sessions, over the last 1 week?
Hello, ma'am. To be honest, I am having 2 to 3 continuous sessions. So reading was not possible from my side. But what you have said, I have understood. There are around 6 types of patents, how to file procedures.
No, no, it's not 6 types of patents. It's probably different types of IP, right?
Yeah, yeah, yeah.
Yeah,
Different
exactly.
types of IP. I am
Yeah, it's
extremely
the different
sorry.
types of IP. Yeah, patent is only one type. Patent is
Yeah,
only one
sorry,
form of
sorry,
intellectual property.
sorry.
Yes, sure. Among the various discussions that we had, what remains top on your mind? Maybe some features of a particular form of intellectual property or anything. You can just share with us one or two or three key points that you had probably noted or just stayed in your mind over the.
Yeah, I would like to share it. When there is a unique idea, some disturbance, I suppose. When there is a unique idea from a person's mind, he for that you need to patent it because there is a chance of other person stealing the idea and doing something and taking credit without his hard work. So for that purpose, patent registration is required, and there are
Hmm.
some various types of what you say IPs. For example, if for example, I invent a pen which will last for a year, so I need to get it
Yeah.
registered that I am having so and so idea, and after that I need to get it a trademark registration done. TM means it is a trademark trademark is under progress.
Sure.
R means it is registered.
Yes, yes.
So these are some things which I have uh, got a idea.
Good, good. Very nice. And I really like the idea that you had of the pen, right? So pen has already been an invented subject matter, but what have you improvised over this? probably the long lasting ink or pen, the effect or whatsoever it is. You come up with a technology where this can be used for about a year, or I mean, depending on the usage or whatsoever it is. So it has a long lasting, maybe a gel or something of that sort that you have devised. So that becomes the inventive part. Good. Thank you, Saidi.
You're
Deepak,
welcome. You're welcome.
yeah.
Madam, just I think you you are asking me the question if I think that something has come into my mind.
So
Am
what
I
just
audible?
remains on your mind of what we discussed in the last class? Maybe one or two or three key takeaways that you had and that just stayed in your mind.
Okay, I mean some why IP is important.
Yeah, right.
It's like that it is because of to encourage the innovation and the creativity, like promotes economic growth, etc.
Yeah.
Protects the rewards of the creators. Means the creator person who is creating the person, just to protect him and to rewards.
Yes, yes.
Encouraging the, I mean, licensing, etc. That is to be done because if you suppose if I'm making so many things new and I'm ultimately I'm not going for the licensing, so
Yeah.
I think somebody will take this as Mr. Puyatel told. So I think
Yeah,
that is to be done
that's right.
in number.
Yeah, yeah, absolutely. So the key takeaway here being that if we don't protect, there's someone else who will take it away, or somebody else will
Yes.
protect it, or
Yeah. Correct.
somebody else will make use of it, right? So that is where the importance of IP lies, and of course the economic aspect of it, and then the rewarding part of it, and various other things. Yes, yes, absolutely. So can we go over to Kashish? We would love to see you on video as well if it is possible for Alimati and Kashish. It's just for this duration of time. Once the session starts, we can all just keep puzzles on. We can close our videos just for the bandwidth purpose. Yes, Kashish, please go ahead.
Yes, ma'am. So
Hello, good
last,
evening.
hello, ma'am. So last class we discussed about what is IP, what is the importance of IP, what comes under IPR, and uh, what are the exact definitions of these four types of IPR:
Yes,
trademark, patent, copyright. Also, we have discussed about design, something like that. Yeah.
yes, yes.
So yeah, and why it is important to why what is the purpose of IPR, so that.
Mhm. Yeah, right. So the last class, there was one important thing that we discussed, as Kashish has rightly pointed out. We came up with the exact definitions of each of these forms of IP, which otherwise we would be mincing words. We would have probably suggested to our clients, why don't you try a copyright or a trademark? Which otherwise would have been good, which otherwise would have fitted a good patent or something like that, right? So we are very, very clear with our legal definitions now. What is a patent? What is a trademark? What is a copyright? What is a design? So they have one very, very unique feature. Each of these forms of IP have a very unique feature in themselves, which is why we brought them under different categories. We also understood in the last class that all these IPs did not come at the same time. It's like a huge bouquet, right? It's like a bouquet of nine flowers. And all of these did not just come up all of a sudden. So there are some which are traditional forms of IP, like you have patents, trademarks, copyrights, which have been there for a very long time. And they also came at their own pace and time, right? If for example inventions, they would go to the king and then they would write the whole invention on paper. The king would affix his seal, and that's where innovations used to be protected. They said everything is open to the it's displayed to the public, but don't copy it, don't repeat a similar innovation, try to improve over it or try to come up with something new. Again, when it came to copyrights, we thought it's perfect with handwritten forms of work. But when it comes to printing press, the moment printing press came up, there was a lot of hue and cry. The question came up, how do we protect it? Because the moment printing press came, it was identified that it is very easy to copy them, reproduce the work. So that's where the whole idea of copyright evolved, and this is where we are today. So Kashish has brought about a very important aspect, is each of them have their own definitions of intellectual property. Each form of IP has its own definition.
Ma'am, also there is no copyright or patent for a lifetime. There are time duration. Yeah. So
Correct, correct. They are time bound. That's a very important point again, right? And that's where we try to bring about the distinction between property and intellectual property. Intellectual property is also a form of a property, but what happens that in case of a tangible asset, like you have your immovable assets or movable properties, it is for a lifetime plus whatever the lifetime or whatever the legal has. But when it comes to our forms of patents, trademarks, copyrights, etc., we started to keep them time bound properties. The reason again being, in case of patent especially, you cannot just keep inventions to yourself, right? So that's where they have a very clear cut term saying that you can patent it and you will enjoy the exclusivity only for a period of 20 years. After that, it has to come into the public domain. You cannot, unless you're going on adding more innovations to the existing subject matter or something, which is what we call as evergreening. There's a concept called evergreening. So unless you're just adding on to a lot of these things and just extending your patents. Otherwise, it's time bound again. Yes, that's absolutely right.
Any innovation cannot be patented.
Yes, Deepak ji?
Any innovation, suppose
Yes,
that it cannot be patented.
yes. Any innovation just like that cannot be patented. So we have a list of what cannot be patented, right? Is that what we are discussing, Deepak ji?
Yes, 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 yes.
Yes,
That's
yes. So not everything can be invented. In the US, there's a slightly different approach to this where they say anything under the sun made by man is patentable. But whereas in India, we have a list of 18 items under Section 3 and Section 4, which says what cannot be patented. In fact, that's precisely the subject matter of today's discussion, where Swati will be engaging us with a very interesting session on both protection as well as enforcement of intellectual property rights, especially patents, protection and enforcement. But you're right, Deepak ji. There are about 18 items which you say which are not patentable.
for
That,
example, and from my point of view, if a medicine which is a life-saving drugs and it cannot be patented. Suppose a person is a medicine invented and something which can help a dying person immediately, say cancerous. Suppose say, a person has put a medicine. Can it be no, I cannot give it because it is patented. I cannot produce it. Is
yeah.
it like this? Something like this? These are
Huh.
things.
Good, very good point. Actually, all these come under, probably in today's discussion, we'll have something around something called patent licensing. Okay. So usually what happens when it comes to drugs and medicines or something which is life-saving, and suppose let us say we are a company where we have manufactured, like you very rightly said, a medicine for cancer or a medicine for AIDS, and this is something which has to be manufactured in bulk. Likewise, we
Yes.
had COVID vaccines. That's the best example we can even think of.
Correct.
So, if the company which holds the patent for these vaccines or these particular medicines said that we are going to hold the patent for ourselves, and unless somebody approaches for license or something, or for whatever reasons, we are not ready to give it out. How do you manufacture these medicines in bulk? So there is one option. There are basically two options. One we call as voluntary licensing. Now, this is what happened during COVID times. Most of these companies which held their patents to these vaccines, they gave a voluntary licensing to some of the organizations which were ready to manufacture them in bulk. They said, okay, go ahead and manufacture because this is very, very required for the humankind. Again, if suppose they approach, now let us say Deepak ji approaches my company saying that I want a license for this particular drug, which is very, very relevant for cancer patients, and I can manufacture it at half the cost of what your company manufactures. Right now, that was the Natco versus Bayer's case also. There, what I can do is now suppose I don't grant the patent to you or the license to you. So Deepak has the right to go approach the patent office and seek for something called a compulsory license. Okay, and that's where the compulsory license comes in. So, Saideep, you have a doubt regarding secret recipes. Is it really protected? What if the person who knows the recipe out of the secret ingredients? Okay, these are basically protected under trade secrets. We had discussed this in the last class as well, right? So you don't want to reveal the recipe, or you don't want to reveal certain things. Yeah. So thank you, Swati. Thank you so much for being here and just in time. It's perfectly good. So I'll just very quickly introduce to my small team of very, very interested students. We have Mr. Deepak Ji, we have Saideep, Kashish and Elamati. They are all professionals. Deepak ji is not a legal professional, but a little more than, but everything he talks about is like as good as a lawyer. So we can consider him as a quasi lawyer in our group. Otherwise, the rest of them come with legal.
Okay, except me actually.
That's
Yes.
lovely.
So let's quickly start with the session. I'll give a very brief introduction about Swati, and we will take this forward. So, for the participants, your instructor for today is Swati Mittal. Swati Mittal is an advocate and managing associate in IP litigation at LexOrbis. She's a patent agent and attorney at law. She holds an LLM in IP and technology law, an MTech in biotechnology, and PG diploma in patent laws, both in the US, Europe, and India. And she has diverse knowledge and expertise in handling patents, trademarks, designs, all sorts of intellectual properties. She has more than like about 12 years of experience in IP, been there, done that. She's handled prosecution, litigation, enforcement. She has appeared before IP offices, the Supreme Court of India, high courts, district courts, and various judicial forums. And she comes with a vast experience, and she's actually given me a very brief profile of hers. And she told me that Pratima, just keep my profile short because my experience will speak all of it during the session. So we are just awaiting Swati. Thank you so much for being here, and over to you.
Thank you so much for a lovely introduction. I hope I'm audible to everybody in the class.
Yes.
Yes.
So it's lovely. It's a small group. We can have a nice interactive session. And to start with, I am told that you people are aware about the basics of IP at least, and you were also introduced into the basic elements of patents. Okay, so first of all, I'll just take you brief of the topics that we'll be discussing today. We'll be talking about patent rights. I didn't get time to make an elaborate PPT, so I'll just quickly run through some slides and then more of face-to-face interaction. Because you can pick up the Patent Act, I can even take you to the IP India website to see the relevant provisions. But it's the basic one-on-one discussion that we'll have that I think will be more enriching. So we'll talk about the importance of patent rights and the patentability criteria, which I think you're already aware of. Section 2, 3, and 4 with some conceptual questions that I'll ask to see if you are able to gauge that. If somebody tells you that is this patentable, will you be able to judge that or not? Some things about patent oppositions, patent revocations, which are a part and parcel of the patent prosecution. When a person goes and files a patent, it's not just that anybody and everybody can get a patent without any sort of problems. So I'll just lead you through that, and then at the end I'll tell you about how do we enforce the registered patents. First of all, before I go to the next slide, I would like to know from the participants that can somebody tell me what exactly is a patent right? Anyone?
Anything, any new invention, any new inventions, anything like whatever we invent, we can make it as a patent or something like that.
Anyone else would like to take it? So basically, Kashish, you're right. So there is anything that we invent, basically that we come up with, is eligible for a patent, but there is certain criteria that is described in the Patent Act, which is actually universal. It is also in other countries it's applicable. So patent is a territorial right. It's a monopoly right. We call it as a negative right, not a positive right. It's a set of exclusive right granted by a state. That means your own country. It's territorial in nature. So India grants patents to specific set of people who apply for patent in India, to an inventor or their assignee for a limited period of time. Can anybody tell me how much time is that limited period of time?
I think 21,
Close. It's 20 years.
20 years. Okay.
In exchange of public disclosure. So we often refer patent as a...
That means 20 years it will be protected, and 21 years it will be open. That's what.
Yes, after just next day after the 20th year, it's open for the public. So what happens is there is an option of so basically we call patent as a quid pro quo. That means you are giving something and in exchange you are getting something. It's a negative right. It helps you to stop others. So if patent right is not something that is giving you only exclusive right, but what it is giving you is a right to stop others from manufacturing, using, selling, import, export of something that belongs to you. Okay.
Okay.
So
Yes.
that's why
I
it is
had
called a negative right.
understood because I had one. I mean, one time one of my uncle. He's no more now. Actually, he invented generally for water treatment in Delhi. So water treatment plant, he invented something that's water treatment for clarification. We use alarm. So and it is a huge amount of is required. And ultimately, he invented some. Of course, I know what it is. So and that time he told me that no, after 21 years.
No,
So
no,
that's what
it's
I
standard.
told it.
It's 20 years, and in
Latest
fact,
20 years.
in India
20.
there is no patent term adjustment. That means in US, US and others, there's few other countries where law allows, supposing there has been a delay of 5 years in granting a patent by the patent office, which is not at fault of a patent. For a person who has filed a patent, supposing I filed it today, I keep waiting for my grant. I have done everything in time. I have replied to every office action in time and everything, but still the patent office took about 5 years. So then in US there is an extension of term by that many days, so that extends it beyond 20 years. But in India that is not there. So in India it's strictly 20 years and nothing else. 20 years from the priority date, not even the filing date. I supposing filed a an application in Canada somewhere, and I'm claiming priority of 12 months from there in India. So it will calculate the 20 years from the date of Canada application, not from Indian application. So that is one concept that you have to remember, that the 20 years term is calculated if it is an ordinary application straight away filed in India, then 20 years from the Indian application filing date. If it is claiming priority from any other application, or say supposing international application under PCT, which through which you can enter multiple countries, then it will be 20 years calculated from that date. And basically what patent means is a patent meaning invention granted. I hope I'm audible.
Yes, yes, yes.
Yeah.
Yes,
So
yes,
what
yes.
is a patented article and patented process means an article or process in respect of which a patent is in force. But generally, when somebody talks about a patent, it's either a product or a process. There is no patent on an idea. Supposing you say, I have got a wonderful idea, I would like to patent it. It's not possible. It's a
It should
it's
be
a it's a
it should be
very
materialistic, material. It should be materialistic
It's not
point of
just materialistic, it should be a product of process. Now, that takes me to what is the criteria for patentability, right? But before that, what is the importance of patent right? It encourages development, obviously prevents duplication of research. The people who patent it can claim royalty. It actually gives you legal recognition as an invention. In terms of an article that I publish, I'll be just recognized as an author or something that I've developed. But with this, I get a commercial right as well. So basically, patents are more of a commercial source of they are source of revenue, right? Now, when somebody says that any invention that can be that is somebody creates is a patent, is what patent is. So invention is actually described in the provided in the Patent Act as a new product or process involving an inventive step or capable of industrial application. So this definition tells us that what is the criteria for patentability. It's supposed to be new, it's supposed to have an inventive step, and it is supposed to be capable of industrial application. So I think everybody knows what's new, which is not published or claimed anywhere. Capable of industrial application is where the invention is capable of being made or used in industry. An inventive step means a feature of an invention. I think there's somebody's audio that is if everybody else can close their mics. Thank you. So inventive step means a feature of an invention that involves technical advancement as compared to existing knowledge or having economic significance, or both. That makes the invention not obvious to a person skilled in the art. So what is important? Who is a person skilled in the art that this act talks about? That it should be not obvious to person skilled in the art. Does anybody have any idea about who is person skilled in the art? So basically, I am supposing making a chemistry related invention today. So the art is, the field of invention is chemistry. Even in chemistry, I'm working on certain types of chemicals which are supposing lubricants. Okay. So in lubricants, there is somebody who is expertise, who not exactly a very subject matter expert, but somebody is holding a PhD in organic chemistry or chemistry science or something, who will be able to understand if I make an invention of that area. That person is skilled in the art. Now, why this is an important criteria is because in most of the places where your enforcement happens, where somebody challenges your patent or where you have to challenge somebody's patent, this concept of person skilled in the art becomes very important. You capable of industrial application, generally all inventions mostly that are filed for a patent, except for few frivolous patents, most of them are capable. But and if somebody is careful, does a proper patent search, then it might be novel also. But where people find it most difficult to clear in prosecution, or when their patent is challenged, is to come out of inventive step. Some people are not able to even convince the patent office that my invention has over the existing some technical advancement or some economic significance. So or both. So this is something that is the most important concept in, and it can take like 3-4 classes to just talk about inventive step, but I'm just giving you a brief idea about it. So we have discussed about it, what all this is. So when we say novelty, it should be new invention. New invention means anything that is absolutely novel. There is no matter in the public domain, neither in patent document nor in any other non-patent document, like any research article, any catalog, any brochure, anything. To challenge on the basis of novelty, one needs to use only single document. So even patent office, if it finds that there is a single document with all the features of my invention, which I have claimed as novel inventive features, if they are all present on one single document, then that is challenged on the basis of novelty or objected on the basis of novelty. It is a ground for opposition as well. It is a ground for revocation as well. And it is a ground on which the patent can also be rejected under 21J. So this is an important thing. And even when people take patents to patent infringement, when I file a patent suit against somebody, the first thing they will attack is if they find a document to challenge novelty, or they want to challenge the inventive step, then that is the way they will try to invalidate my patent, which is why understanding of these concepts become very important. There are some exceptions to these novelty, where there is something that is published without the consent of the inventor. Somebody took my invention, stole it from me and published it so that I cannot patent it. If I'm able to prove that, then that will not actually that will not hit my novelty. And if an invention was published in consequence of a display in an exhibition which is notified by government, or supposing government does this startup Kumbh Mela or some startup, they have invited us to present their ideas in a conference or in a, so if that happens, or if you are reading a paper before a learned society, then if it's within the 12 months before the filing, it is an exception to hitting your novelty. And if you had to reasonably do a trial, so there was a very famous case where a person did trial for many years because he had invented something for the footpath. So footpath, to understand, it needed many people to walk upon it for a longer period of time to understand that yes, this is something that my invention is working. So that was a reasonable trial for that particular invention. So if you have done a public working for a reasonable trial, then that is also an exception to hit. It will not hit your novelty. I've just described what investive and these two things are. So now, what if something is there which is found which hits the novelty of your invention? It then either the controller will refuse your application if you file it, and otherwise you will have to amend. Now, before I proceed further, I want to understand whether you know how a patent is filed. So I'll give you a brief overview of how it is filed. So I'll just take you to the website. So this is the intellectual property website, which is like for you people who want to learn about all forms of IP. So the more you know, explore the rules, the act, and read about it. And there are certain FAQs. Say patents has the forms and fees mentioned. Publications tell you all about the manual helps you in what the guidelines would be. What is the manual tells is how a patent office looks and understands the concept in different. It gives you details about every section that is mentioned in the act. In e-citizen, you will find the acts, the rules, and so on. There are FAQs and there's IP awareness. But what I wanted to show you was that if you want to file a patent, anybody can go and file a patent, but generally you use a patent agent for that. There are certain rules. So there is that you have to file form 1, form 2. So basically it's like an application form that you fill in. You fill in certain details. Form 2 is what we call the most important form. That is your complete specification, without which a patent cannot be filed. So that is there. So there are different, so you basically go on comprehensive e-filing, you find this e-filing patents, and it takes you to this login. So you kind of log in, and I will not be able to take you inside the interface because as of now I don't have the credentials in this. So you just kind of log in this, and it tells you what you want to do. You want to file, and I can probably show you through FAQs. So the patent office is basically given a brief if to a layman if he wants to know anything, how he has to file, who can apply for a patent, how can I apply for a patent. This is a basic document that you can read. So it just says that you first register. The filing procedure is explains that you first register yourself, and then you log in, and then you select which forms you have to enter. So it gives you an option of new application. It gives you an option in new application, 2 categories that you would, and in that there are multiple categories that are there. One, is it an ordinary application? That means are you straight away filing in a patent office? In that also you have an option whether you are filing a provisional application or a complete application. Now I'll hold here and I'll try to explain you what provisional and complete is. So anybody who comes up with an invention is somebody, sometimes if they are working on an invention which requires certain amount of trials and experiments that happen, but they are scared that they want to at least protect the broad scheme of their invention. They want the broad objects of their invention. They know what result they are going to get, but they need a proof of concept. So they are ready with the base. They have not given it a proper trial. So they file a provisional which does not require your detailed claims or detailed description. It just requires your statement of objects of invention, a brief summary of what your invention is about. You can file it just and protect it from that very date, so that tomorrow if somebody in parallel comes up with that I also have a same invention, you are first to file, because India is a first to file regime. That means you file a patent in India first and then only. So they say file first, publish later. That's the rule that is there. We try and tell every inventor, every scientist, every person who's coming up with an invention, you file a provisional and you have 12 months from the provisional to file your complete. And when you file your complete, that complete specification should have all your examples, drawings, claims, everything about an invention. So there are certain parts of a patent specification. You have to give a title. There has to be an abstract, much like a research paper. There has to be a brief description about your drawings. There has to be a detailed description about your drawing. There have to be field of invention, in what invention field that you've worked in. There has to be objects of your invention. What problem are you solving? You have to also give the background that earlier this problem was solved by such and such method, but the inventors of the such and this application has come up with this method which is overcoming the problem which was first coming up in the previous inventions existing in the art. And then you describe, give examples that this is how this invention is performed. In this manner you perform it, and then you achieve this result. The best method is this, and then you claim. And the claim starts from I or we claim, and then you start that it is a certain claim that I am claiming this or we claim this. So this was the process I was talking about, the procedure. So you file an application, you save a draft, you preview, and then you digitally sign, and then you make a payment. It's a simple procedure. So it talks about, and you need digital signatures, by the way, in this. Coming back to our presentation. So anybody can file a patent, but you need a patent agent who is experienced to handle the nitty-gritties of the, they have experience. They can also perform a patent search for you. And what is a patent search and why is it important? So patent search is something that you do to make sure that you are not filing a patent for something that is already patented or published anywhere in any document. There are paid databases for that. There's also a patent search application. I can show you on the Indian Patent Office website how a layman can do a patent search. You go on public search. Can everybody see my screen? It gives you an option of public search. Can you see it?
Yes, we can see.
Then you click on patents. It gives you a patent search like this, where you can choose different criterias, and you can say that, okay, I want basically the applications that are filed in. So no, let's not go for application. Let's go with something like, I want an application which is in the field of which has COVID mentioned. Okay. And it says there are 1552 documents which have in their abstract COVID mention. That means they might be doing this invention, maybe doing something related to COVID. Okay. But what if I want to, what it gives me certain criteria I can do. Say, supposing I want something in the claims which talks about, I can also change the field. So complete spec, in the complete spec, I need something that talks about a mask. Okay. So we have two criteria now, COVID and mask related inventions. Now the documents came down to only 239. So this is showing only the published applications in the Indian Patent Office database. Okay. So now this is giving me, this is narrowed down. So there is facial mask recognition based locking system. There are multiple things. But what if, so Indian Patent Office website has a lot of capability, but generally to do a comprehensive search, we do a search in this also, but we do a search in other platforms that are paid, which give you a much wider criteria. And there are similarly, you have options of Google patent search also, you know. So Google patents, this is somebody who is not having that kind of expertise in searching can also do it. So I want COVID, again, same thing. Mask. So now this is giving me 42,168 results. Okay. If I want, I can also sort it. I can also refine the advanced options. I can just say that I want it only in the abstract and all the words in abstract, and then I can just refine it. It's gave me 8 results. So then I can also, you know, just say maybe what is filed in US only. It gives me 1 result. So this is how you can actually, as a layman, also use the algorithm and actually do a basic search. But it's always advisable to ensure that your data not challenged, to probably get an expert's opinion, because what happens is sometimes people are very clever to draft. So they draft in such a manner that you will not be, even if you put the right keywords, sometimes the document does not get revealed, and later the patent examiners and controllers in different patent offices who are an expert in searching, they give you that document in the examination report, and they raise an objection on your patent. So that's why it becomes important. Taking back to the presentation. Now, I think with the brief that I have given, you have a basic idea of that. If you want to go to do a basic search also, you can go use the free tools which are available if for an ease of access. And also you can use platforms like there's Thomson mentioned, there is Questel Orbit, there are a lot of softwares that are there. There's Total Patent, which are existing in the market commercially for doing the searches. There are for chemical related patents, for chemistry structure related patents, there are different softwares there. You can actually have the structure search done. Then for biologically, where there is sequence search that you want to do, for that also there are softwares. So these are some things that are not easily, you can do these on free platforms. For those, specialized softwares are required. I hope I'm clear till here. I would love a feedback from all of you. I can go slow if you are not able to follow.
Ma'am, could you mention some of the hardware related software where patent could be?
Sorry, I didn't get you.
To do a patent search for hardware related products or inventions.
That you can do easily on any platform, because mechanical inventions or hardware or software related inventions have certain specific keywords that you can use, and any software will be able to do that, be it paid or free. And free
Okay.
software sometimes have a lot of you know garbled data also. It's not that, although Google patents has refined over time, so good, it gives you very good results sometimes. And you have eSpaceNet, which you use for the European Patent Office search tool, is also very nice. And any of these platforms that you use, you can do a search for hardware, or you can also do for a software. That's not an issue. But I hope I'm able to clarify that we have different ways in which we file an application, what are the criteria that a person has to keep in mind for patentability. And now we are moving to what is the most important criteria in the Patent Act, that it should be a patentable subject matter. Besides novelty, besides inventiveness, besides industrial applicability, the fourth most important criteria is it should not fall within Section 3 or Section 4 of the Indian Patent Act. Interestingly, I will tell you some cases that we have been recently handling, and it has been, you know, we have had both Section 3, Section 4. A lot of appeals have come in, and we have their patents were refused. Our clients' patents were refused, and they were taken. We have taken them to court, the patent office, that we have appealed against them, that they are patentable. So, for example, that so anybody knows what is the patent criteria, these under Section 3 and 4, what are the things that are patentable or not patentable? Just quickly, if somebody can just come up. Patent Act has defined certain specific strict criterias, which means first one is 3A, which says frivolous or contrary to well established natural laws, which example, a machine which relates to, or an invention that relates to perpetual motion, right? Then there's Section 3B. Primary or intended use or commercial exploitation could be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health, or to the environment. Now, interestingly, the examples given here are taken from the patent manual. Inventions that induce riots, criminal offensive behavior against the accepted norms of society, terminatal technology. Recently, there has been a trend which is growing where e-cigarette related, which is prohibited under a different act. The sale of e-cigarette is prohibited under a different act, but it is being rejected on a large scale because of Section 3B. Because according to the patent office, the tobacco related products do not cause serious prejudice to human health, but the e-cigarettes do. So, which is why across India, across all the four IPDs, Bombay, Calcutta, Madras, and Delhi, there are plethora of appeals right now, all challenging patent refusals under Section 3B to all e-cigarette related inventions. They have started rejecting even the flavor substance inventions which were there, flavors for the e-cigarettes, which do not fall under 3B, but they are being rejected under 3B per se, because they are related to e-cigarettes, which is basically, as per patent office, serious prejudice to human health. So you see how sometimes you have to even reason out things which are patentable. You may have to appeal. So we have been appearing in numerous appeals before different forums. I have myself appeared in Madras, in Calcutta, in Bombay, and Delhi, for all such different various kinds of appeal. And there are cases where, as I go forward, I'll just tell you. For example, so this is 3C is mere discovery of a scientific principle, a formulation of an abstract theory or discovery of any living thing or non-living. Section 3D, that is mere discovery of a new form on a known substance. I think voice is echoing somewhere. Which does not result in the enhancement of the known efficacy of that substance, mere discovery of any new property, or new use of a known substance, and mere use of known process, machine, or apparatus, unless such known process results in a new product or employs at least one new reactant. And this is the most difficult section, you can say, the most cited one when it comes to when there is for pharmaceutical substances, Section 3D is often quoted. Even for electrical, we have had cases where telecom related inventions have been actually said that they are basically, they are just new use of a known apparatus or something like that, or there is, it does not. So there are a lot of things that come under 3D. This is very commonly used, and there are multiple case laws on this that are there in the public domain on all forms of this thing. And it is in US, new use of a known substance is allowed, whereas in India it is not. So the Section 3D is something which is very particular to India. It is not. It is not a common, section which you will find in other jurisdictions. I'll just skip the chemical part. Then another section where people are often stuck are Section 3 and Section 3F. So mechanical inventions are often stuck in mere arrangement or rearrangement of known devices. Sometimes there are things which have already known in the art to have a certain amount, a certain way to function and produce a certain result, and maybe the rearrangement, or as per patent office it's the rearrangement, but we have not rearranged, we have added a certain process to make that device, and the efficiency of the whole process has increased. So you have to really convince the patent office that it does not fall within this section. Again, Section 3E is where it says that if you have just, it's not a synergistic composition or synergy, you have merely mixed the products. So supposing, for example, commonly ibuprofen, where you said that you have two, there are many such medicines where you have two medicines who have different effect and they are combined. So they say that that is not allowed as a patent. You need to have a synergistic effect. That means they both together produce an effect. Otherwise, I can claim one separately, I can claim two separately, and I can mix both of them and claim third patent for that. So unless or until they both as a synergistic composition produce a new result, or is having a surprising effect, in patent office, you in the patent documents or the patent field, you will often hear the term surprising effect. It should be producing a surprising effect. So that surprising effect is something that is for these kind of combinations. It was not earlier happening, but when we mix these two and in this particular ratio, it somehow gave a surprising effect. That is what is not mentioned in your acts. That is something that comes up from the patent prosecution, and by way of practice, I'm telling you this happens. Then Section 3H is methods of agriculture, horticulture, and Section 3I is again something that is causing a lot of issue for a lot of people, because method of treatment is not allowed in India as such, and there are many, there are some variations in US and Europe of the same section, with some people allow certain things, some people not. But the problem is, lot of our diagnostic and therapeutic methods that are coming in, and those are being read by the patent office as a process for treatment. So here what is important is how you draft your claim. If you start your drafting of a claim with, I claim a method of treatment of such and such disease by injecting such composition in a human subject, if I am doing that, then that will be rejected under Section 3I. But when I say a pharmaceutical composition comprising of such and such things, producing this kind of effect, then in that case, that will be most likely to be patented. So it also depends how you are drafting. Then Section 3J, plants or animals in whole or any part thereof. And then Section 3K, which is often the softwares and the AI related inventions often fall under this category. A computer program per se, a mathematical method or business method or algorithms. So recently the guidelines for computer related patents were also published. Draft guidelines for circulated were public comments, because a lot of people had to actually approach court for an interpretation. People were the patent office were left and right rejecting all AI related inventions, and AI is the future. So to explain that it is not only a computer program per se, it's not only an algorithm, it was becoming day in and day out very difficult. The courts were interpreting it And then all those interpretations are now combined, and they're also used by the patent office in the new guidelines that they have published recently, which gives you a more elaborate, which gives you a more, you can close the door, which gives you just a sec, उसमें वहाँ चिटकनी लगा देना, उस वाले अंदर वाले उस वाले गेट में चिटकनी लगा देना. So which produces a such certain kind of these kind of things. So supposing there was a case, and in which Justice Pratibha Singh said that she denied, she also said that this is not patentable because it amounted to a business method. So supposing I am doing a business of e-commerce and I am gifting rewards to somebody in that, by after every shopping, and then after everything I add to my cart, there is something that goes in my maybe a coin or a gift or sweepstake, something like that keeps coming,
Right.
and then I can encash it somewhere, and then I claim that this all process I'm using and it helps me, I can, I mean something like that, of that sort, and that will amount to be a business method. So softwares per se actually are covered under copyrights. So my this particular so examples of something that can be patented is inventions used for improving the internal performance of the computer, controlling, measuring, or testing process, or used for external data processing. Section these are more earlier form of. I have these days you also find mobile applications being as a system. What they do is they have a network architecture and a system, they claim both hardware software combinations. Earlier, the section 3K, actually it's very interesting. If you go online and you read how section 3K has evolved over time, you will actually see a lot of interesting developments there that has come over time. From Diamond versus Deere, there was in US a case, very interesting case happened, Diamond versus Deere, where a method of rubber curation, and which increased, which had kind of increased efficiency of the whole process. That was for earlier, the court held that it is uh, patentable because it is not it is increasing the efficiency of the whole process. Rubber curation process has increased because of that algorithm. It is having an effect on the hardware, on the actual physical effect it has having. But from there we have come a very long way now. We don't need a novel hardware concept. Earlier there was that the hardware and software both have to be novel, but now you don't need a novel hardware. So I sometime when you are free, you should read the evolution of how 3K has evolved over time. Then you have section 3L for all literary, dramatic, musical, artistic work, which falls under copyright. That's why it's not patentable. Then you have scheme, rule, method of performing a mental act, or method of playing a game under 3M. Again, 3N, presentation of information, is copyrightable, not patentable. Topography of ICs is under the semiconductor layout. That's a different act altogether under which it is done. Then invention falling within the scope of traditional knowledge. Again, it's a different field of IP altogether, where TechEDL, there is traditional knowledge, digital library, which has a lot of which has a lot of database about the traditional knowledge that exists. Maybe like the healing effect of turmeric, that is something which is already known. So US filed a patent for it, which was been known in ages. It is our traditional knowledge, our you have our in our grunts and in our books and literature of lot of dating back to like many ages back. This effect was known, so it has a traditional knowledge, so nobody could patent it. And then comes section 4, which is related to atomic energy, not patentable. So in this, the Ministry of Atomic Energy, so basically the government, the controller, if he feels that defense related, this can be, there is somebody, a thorium, or so basically the atomic energy, which is related inventions like uranium, thorium, all those things which are the which can be used in production of, say, which is nuclear power, nuclear bombs, and using nuclear missiles and all those things. Because of defense purpose, these inventions are not patentable. And the controller of patents generally refers, if he finds in his opinion that he needs some kind of opinion from the defense ministry or the Ministry of Atomic Energy, the Atomic Energy Department, to review the patent, then it's there. That brings me to one more thing. Nobody is allowed to file a patent in any other country first and only file it in India first, and or take a foreign filing permission. Again, it is also for the same reason, for national security of the country. Nobody should be able to patent something that is against the defense of the country, which is why every country generally has this rule that an inventor of a particular origin, supposedly the invention has been done by two Indian inventors, the invention will be first filed in India. It will be the person will have to wait for 6 weeks for it to be objected to. If it's not objected, then he can go and file it somewhere else. But if not that, he will have to, under section 39, first file a foreign filing permission and take a permission from the patent office before he enters in another country. So interestingly, I have some questions to understand how much you people have understood, which often appear in the patentation exam. So I thought it will be useful for you people here as well. So can you see, all of you, the questions?
Yes, yes.
I'll just do one or two and then I'll skip ahead. So Rohan happened to visit Himalaya along with a trekking team. While staying there, he wrote a book related to Himalayan mountain range, took some video, made a novel, an attractive device for easy trekking, and discovered a stone naturally occurring there. He wishes to get IP rights on all of them and approached you for filing the application. He can apply or register for, choose one of the options, or you can even choose more than one. Yeah, I can see more than one option there. Copyright for the book and video, yes. I also see a possibility of the device which he has developed for easy trekking. He can actually file a patent and design for that device, but it will be subject to that it fulfills all other criteria as well. The reason, because it says attractive device, so it's an aesthetic appeal to it, and people would want to file the design of the device as for also protection for that. But discovery of a stone, it's because it's already existing in nature. Something you discover cannot be patented, it will not be applicable for any form of IP. Which of the followings are not patentable as per the Act? Anyone? B, C, and D, all three are not patentable. Because one is computer program per se, the second is discovery of any living thing, and the fourth one is the clock having 10 hours, which is against the natural laws that exist. How can a clock have 10 hours and each hour divided into 100 minutes? That's against the nature, against the law. So we'll now move to opposition proceedings. I'll be very simply going into it briefly, not going into the procedural aspects. So there are two options before the patent office when somebody wants to challenge a patent. One is pre-grant opposition. That is, any time before the grant, any person. The difference is any person can file a pre-grant. And provided if a person has not filed a request for examination, the opponent will have to first file a request for examination, and then only he'll be allowed to file a pre-grant or a post-grant. Pre-grant is, as it says from its word, before the grant of the application, and post-grant is after the grant. But there is only 1 year timeline for the post-grant. It is not that you can anytime after the grant challenge it. It is only up to 1 year. And pre-grant is anytime before the grant. So anybody can file pre-grant opposition after publication, but before grant, only when a request for examination is filed by way of a representation. Once I don't need to go into the detail of the procedure. There is proper statement, evidence, and all those things are very procedural. But this is one opportunity where you get to challenge someone's patent, and generally competitors have started using this as a very dealing, abusing the process of law to actually not let their competitors' patent get granted. It's been commonly used. Then, but post-grant opposition has a stricter interpretation. It has criteria which is more stricter. It says any interested person. So interested person means somebody who is actually in the same field, maybe working on the same field of invention or has same field of business. Then that person is interested. Again, by way of a representation on a form, and any time after grant but before expiry of 1 year from date of publication of grant of patent. So that's the post-grant opposition. These are the grounds for opposition, both in pre-grant, post-grant, and then the revocation also is on the same grounds. That the patent has been wrongfully obtained, That means the invention has been wrongfully obtained from somebody. He stole from me and he filed for a patent. It should not be granted to him. There has been prior publication or prior claiming or prior public use, which is challenging the novelty part. There is inventive step, that it lacks inventive step. It does not meet the patentability criteria. There is not sufficient disclosure in the patent. There is incorrect or non-disclosure of facts related to foreign filing applications. It relates to a traditional knowledge, or the source of the biological material is not known. These are the only grounds on which somebody can challenge a patent. Beyond this, there is no other ground that is allowed. As of now, I hope this is clear. I will not go into the depth of it. I want to quickly now go into, before I'll just, talk about enforcement. So interestingly, I have been working, and we just got an injunction yesterday in a patent infringement suit. So was basically, what exactly is the enforcement like? How do you enforce your patents? You enforce your patents by way of, first it comes to your knowledge that somebody is having a similar product or a similar process which is in the market. I hope I have all of you here and all of you are awake and not sleeping. So first of all, when it comes to your knowledge, the cause of action for taking any legal action starts from there. As soon as you know that something has, somebody has come up with a similar kind of thing, they have launched a similar kind. Yesterday it was regarding same pharmaceutical compositions, nutraceutical compositions actually. And then we also had a mediation today for I am not on mute. You're able to hear me, right?
Yes, we can hear it.
Yeah. So basically, we also had a mediation for a similar kind of thing, but it was more related to software patents. So somebody launched similar apps with a little different interface, which were having same features that were in our patents, clients' patents. So they were sued for infringement. But the first step in enforcement is you keep a watch. Once you have a patent granted, that if somebody in the market is doing that. And secondly, you also keep a watch on the patent filing. Somebody is filing a similar patent, so you try and oppose it. You do all that. You challenge their file for revocation of their patents. Thirdly, you send them a notice. And cease and desist notice to stop from manufacturing or using or selling or importing or exporting or distributing anything that is actually infringing your patent. If they do not respond to the cease and desist, it is compulsory under the law right now. There's a recent Supreme Court judgment that says that you have to necessarily take a commercial dispute to pre-mediation under the Commercial Courts Act. Section 12A of Commercial Court Act requires every person who wants to file a suit for commercial suit will have to approach first before for a pre-mediation, or give an offer of pre-mediation to the other side, let it fail, then only file a suit for infringement, because the rise of litigation was so worrisome that the caseload was increasing on the courts, and eventually IP matters generally get settled either by way of license, either by way of undertakings, either by way of settlements in any form, one-time settlement, paying damages. So when courts felt that if the commercial disputes are actually getting solved through settlements only, then it should be compulsory that they first resort to settlement and then come to court. So generally they are going to pre-mediation, and then we go to courts. Now courts, the first and foremost thing in court for us, for anybody who is a litigating lawyer, becomes that we need to get an injunction. So what we prepare is a claim chart. We do a claim comparison, not a product comparison, from our patented granted claims to the product or the process that an infringer is using. That is mapped, and that mapping is presented to the court to show that it is falling within the scope of my patent. Yes, I mean to say that ADR, but it's not just any ADR. It is pre-mediation under the Section 12A, which there is specific form for a pre-mediation. Delhi High Court or any other court has a mediation center where you can apply for the pre-mediation. and then resort that and then do it. Then otherwise you will have to file an application for exemption from pre-mediation, and you'll have to explain to court that why it has to be, because sometimes for counterfeit drugs or counterfeit things which are in the market, you cannot wait for mediation. It would actually flood the market with counterfeit. In those cases you seek exemption from the court that if I resort to mediation, this person will flood the market with fake drugs and people will die. In that situation, court will say, okay, I'm granting. So yesterday that was one such situation. We said that pre-mediation will not be something that will be useful. We already sent them notice, we gave them offer to resolve it amicably, we told them let's do pre-mediation, they said no. So that is why now it is of no use. Court was earlier saying let's see if one can solve it in mediation. We kept pressing that mediation will not be a solution. Then when we showed the infringing label comparison, we showed the claim chart, we showed that both the labels of our products have the same product composition, then the court gave an injunction and an ad interim injunction, and the other side is asked to now file a reply. So in this case, sometimes the products are so technical in nature that the courts cannot just rely upon something like that. They need an expert evidence, expert affidavit, somebody from the field who is an expert to give an affidavit that I have compared the, sorry, I cannot share it, the case name. So it is not yet published, so I cannot share it, and we have to,
Yeah, Saidi, these cases are not published yet. They are not reported cases, so the names of the parties, etc., cannot be revealed. But what is important here is the takeaway for us, right? In terms of the pre-litigation mediation and the stages that are involved in the enforcement. Yeah, thank you.
So then, once generally injunction happens, most of the parties are likely to settle. They give an undertaking and settle because now they cannot sell their product, they cannot use their process. So in some cases, injunctions are not granted. In that cases, the courts, they ask some people to take, have an affidavit, because they have to feel for an injunction. There are three criteria that you have to fulfill. First, you have a prima facie case. That means on the face of the case, you have everything in your, you have made out a case of infringement. Second, your not getting an injunction will actually cause an irreparable harm to you. Third, the balance of convenience also lies in your favor. You have to show the malafide of the other side. You have to show what all wrong they have done. So we have cases where people are related to each other. The parties, maybe they were a distributor or they are a manufacturer for us, where we had given them some things. They copied it, they started using it. And these kind of things often often tilt the favor, in the favor of the plaintiff. The balance of convenience is often favored because of the circumstances that are proven in the case. Now, in case injunction is not granted, in those cases courts generally ask for an affidavit of sales or some kind of pre-term, kind of pro-term deposit, that okay, till the time, the whole trial will take long time, it may take 1 year, 2 year, 3 years, but till that time you need to deposit a security before court, or you can keep an account of sales figures and keep submitting an affidavit of sales every month or every quarter. So these kind of measures are regularly taken by the court to ensure that the rights of the plaintiff and the defendant are both to maintain equity and justice. So there are some cases which are straightforward, and there are some cases that are not straightforward. So when these cases are not straightforward, generally the injunctions do not happen. In those cases, you have these kind of measures that the court take. Then there is proper evidence that happens. There is pleadings have to be completed in a proper civil case. You have written statement filed by the defendant, the summons are issued, and then written statements are to be filed. And then they also have a right to file a counter claim. That means they can file for a revocation, invalidity of your patent. If you are saying there, besides non-infringement, the biggest defense a defendant has is invalidity of a patent, they would straight away challenge the validity, that the patents are not even novel, they lack inventive step, then how can I even infringe them? They are using common general knowledge, or they are using something that has been used for such a long time that it is now general public knows it about it. These kind of things are often used as a defense in a patent suit from people who are challenging the suit patents to come out of the case. And then generally when these kind of things happen, one case, two case, multiplicity of litigation starts happening, keeps getting prolonged. most likely. Today, we concluded a final argument. Very rarely a patent suit actually reaches final argument successfully. We were representing defendants, and today it's a very famous case which is going on, which has been watched worldwide. It is a reported case, so I can tell you, a Rosenberger. So CCI, communication components versus Rosenberger. That case is going on, and we successfully represented the defendants. It has now concluded. The judgment is reserved. Let's see what happens. But it was, in this case, we were told to maintain sales figure. We did not let the injunction happen because it was related to antennas. Okay, it was the first case where live transcription of evidence happened, where Justice Pratibha Singh used live transcription. There was a transcriptor that came from Singapore, used the software in Delhi High Court to do live transcription and evidence being recorded, the cross-examination, examination, everything happened virtually. And the main witnesses flew in from US, and they were with live transcription in the court. They were done, and the whole trial was expedited and done in a very fast manner. And then the hearings obviously took place after the trial the final arguments have been happening, and then today they got concluded. So patent infringement is something which is in Delhi. We have specific rules for patent suits in Delhi High Court, and soon thereafter, I think it will be start to follow in other courts as well. So our patent this particular matter fell into a special category, that the patents were actually having less than 5 years remaining of their life. So the judge, Justice Pratibha Singh, invoked that, and she said that I will expedite the trial. And in that, she used all the it was a very interesting case that we used to record the evidence, and it was one of its kind. And we also have a new concept of confidentiality clubs. I recently wrote an article on that confidentiality clubs, which are used by as a measure to maintain. There are certain I have a license agreement with 10 other people. I have sued someone else. He's saying that they are asking too much of royalty. I cannot give that. Then the court will ask us to file in a sealed cover the settlement agreements if they are confidential in nature. And then there'll be a confidentiality club that will be formed. That confidentiality club will have certain members only, maybe 2 or 3 counsels from one side, the other side, and one representative from each side, who can get access to those documents and read it and be a part of it. And they are not allowed to divulge details anywhere else. So that is also one of the most recent phenomena that has been happening, the formation of confidentiality clubs, mostly in the patent suits. In the SAPs, there's standard essential patents suits that are happening. In that, they are most common. These are the recent trends about the patent suits, the commercial matters, the enforcement, how it's happening. We also do raids. That is something, one topic that I thought I'll also touch upon, is that when you feel that other person, you get an appointment of a local commissioner, who is generally a court appointed officer, mostly a lawyer. In case it requires technical expert, then a technical expert who will go and do a civil raid on that premises of the defendants and seize everything that is there, make a report of it, present it to the court, which also acts as an evidence of infringement. So generally, if I feel that they are hiding something and I need data, then I can also I may also file a discovery application. But even before that, I will file an application for appointment of a local commissioner to go and do a raid at the premises of defendant, to seize the goods that are there. They do analysis, and then they file and report, and then that's an evidence of infringement as well. Even if they don't find anything, their report says we didn't find anything. These are the two kind of things that can happen in a civil raid. With that, I think I have covered almost all the topics, from search, from filing, I've not covered drafting because drafting is very technical, but I've touched upon almost all aspects of patent enforcement and protection that I could. I hope I have done justice to the time that was allotted to me.
Yes, indeed. Thank you so much, Swati. I mean, this was a real capsule course, I think, for us, and a capsule course in the true sense, which gives a complete insight into the first part, that is in terms of protection of IP, and the experiences that you bring on the table in terms of what is patentable, what is not patentable, out of your own experiences, out of the cases that you have dealt with. That itself was insightful. And the second part, that was enforcement. Yes, that was a very, very interesting subject matter to have been covered through the session. And this is pretty much what we have, in terms of the material, reading material, or the video lectures that have been shared with the participants. So I'm sure this will be a great value add, for them this forward, take the learning forward. Um, I have two requests. Number one, you mentioned about this particular case, right? Which has just been decided today, and I'm sure it has to be
It just
reported.
concluded today. The
Yeah,
judgment is not coming yet.
it's not come. So maybe eventually, if you could just share the citation with us, that's number one. The second one is what you mentioned of the confidentiality clubs. This is a very interesting subject matter again. And you also mentioned that you've come up with an article, a write up on this, a content on this. So if you could share that, even if you could email it to me, I will share this in the group here. Yeah, so these are the two things. And the third one, I'm sure there's an assignment that, Swati would be sharing with us in terms of just, a roundup kind of a thing in terms of what has been discussed through the session today, so that the participants can just go back, ponder over the points that has been discussed in today's session, and probably take this as a sort of self assessment in terms of what they learned through the session today. So that's it. Any questions? I think
Yes, I would be
you have
happy to answer
answered
the
most of them,
questions.
but in case there are any questions or something that the participants would want to ask, anything specific or any clarifications here of what has been covered through the session, would be good.
Madam, may I?
Yes.
Sure,
Madam,
sure.
Madam, it is to Swati Mittal, ma'am. Madam, regarding the local inspection, what you said regarding the raid. So when when the other side will be uh, uh, there before before the honorable court, will he file any objections to it? And if
Obviously, he can if he's present, then he will say that local commission should be avoided. But it's generally at the court's discretion to appoint. Generally, when we file an application for local commission, it's mostly when we are claiming for ex parte injunction. When we do not serve the other side, that is when or the other side does not appear. And we generally want local commissions are generally done in ex parte matters where we do not want to warn the other side. In fact, people we make a request for even hiding the name of the defendant, so that and the orders are not uploaded till the time the commission is done, so that the people who against whom the cases are filed are not made aware of when the commission will happen, at what time, at what premises the raid will happen. They do not get alerted about it. So that is one practice that happens.
yeah, I was having the question regarding that because if the other side is aware, then he will surely,
No, no. So it happens in ex parte matters where
yeah.
we approach the court without informing the defendant that it's come to our knowledge and we need to conduct a raid.
Ah,
So please give us an ex parte injunction. And in the meantime, we will do the raid, and generally the raid happens within a month. And
mobile.
then after that, it is the report. After the report is filed, when we do the raid, then the person gets to know that okay, now I'm going to be having a case against me. Yes, they are given a copy of the order that they have been injuncted by the court by an ex parte injunction, and then those things happen. I hope I have made myself clear.
Yeah, yeah, 100%. In Motorsali. Here one girl has come. She is 4 years, 8 months. She is also very interested in IP litigation.
Oh, I hope to see her sometime
So
rising to
sir,
be an IP lawyer.
Yes. Any other questions?
no.
Okay. So I think we're good to go. Thank you, Swati. Thank you.
Thank you.
Okay. Yes. Thank you. Have a nice weekend, all of you. I look forward to
Wish you the
meet you
same.
next Saturday. Bye.